We're starting, everyone. Welcome to meeting number 21 of House of Commons, Standing Committee on Government Operations and Estimates. Pursuant to Standing Order 1083C, we're resuming our study on the response of the government to the motion from the production of papers adopted on October 20th, 2025 about the contracts with Stellantis. We are welcoming back some members from industry regarding these documents. I understand, Mr. Jennings, you have an opening statement for us. Please go ahead. The floor is yours.
Thank you, Chair, and thank you to all members of this committee for inviting me back. I welcome the opportunity to provide clarity and additional information in your deliberations related to the Stellantis agreement with Canada. Let me begin by saying that what I said on November 25th at this committee, that Stellantis proposed the redactions, reflected my honest understanding at that time. Ce que j'ai également affirmé le 25 novembre.
What I stated on November 25th, which was confirmed by Stellantis in its recent testimony before this committee, is that Stellantis consented to the redacted version of the agreement provided to the committee, and that these redactions are related to commercially sensitive information.
Parliamentarians to request and view documents. Given the balance, my department seeks to strike to ensure we share information with Parliament and its committees transparently. With the contractual obligations to protect commercially confidential information, we sought to share an agreement with very limited redactions. I also want to situate this in its operational context and timeline, because that matters. Le comité a demandé contrat pour la première.
The committee first requested the contract on October 20th. Given the urgency and the desire to comply with the committee's request without delay, officials at the department proactively redacted information based on their understanding of what Stellantis and other companies have historically requested to be treated as confidential in the past. This was done in part to save time and ensure that the committee received the document as soon as possible. The contract was provided to you on November the 6th.
This committee has the full unredacted contract, shared with you following confirmation that Stellantis consented to doing so. I would also reiterate that Stellantis representative noted Thursday, Stellantis and the department have worked in a long-standing context of confidentiality. Over the life of major industrial arrangements, the department responds to committee requests, to access to information processes, and to other forms of scrutiny. De ce fait, nous avons une connaissance institutionnelle.
As a result, we have a deep institutional understanding of the information that companies consider commercially sensitive. These are the reasons that motivated officials to act quickly, in good faith, and with the intention of meeting this committee's deadlines.
The role of public servants in this work. In dealing with businesses across the country, confidentiality arrangements are a normal part of securing investments, supporting innovation, and delivering good jobs for Canadians. Balancing transparency with the protection of legitimate commercial information is a core responsibility, and we take that responsibility seriously. Pour être en mesure de prendre des décisions prudentes et
to make prudent and responsible investment decisions, the government must be able to rely on commercially sensitive information that companies share with us as part of our due diligence process. They provide us with this information because they trust us to protect it.
Work and essential to safeguarding the public interest. The reason for this is simple. These agreements and the confidentiality required to implement them is vital to protecting Canadian jobs, communities, and workers. Finally, let me close with this. We are here to work with you. My department and I stand ready to answer every question you have. We are committed to assisting this committee in its work, including its review of the unredacted Stellantis contract, with the view of ensuring that all members have the information they need. That commitment is unwavering. Merci.
Thank you very much. We'll start with Ms. for 6 minutes, please.
Thank you, Chair, and I will be splitting my time with Ms. Jansen at the 3-minute mark. Although I was not in attendance at the last committee meeting where you appeared, I watched with interest your testimony, where you told members that Stellantis had been the one to propose redactions to you, after which, of course, Stellantis outlined in a strongly worded letter they did not recommend or suggest any redactions to the CIF agreements we received. Today, you come here and say that it was your honest understanding when you provided that testimony to us. You also said today that officials proactively redacted the documents before going to Stellantis. That's very different than what you presented to committee at your first appearance. And my question for you is this: who told you to lie to this committee?
Great. Thank you for your question. I'll start by just saying that I've also reflected since my last appearance before you, and it's clear to me that I could have been much clearer about the redaction process, and I regret that the committee was left with a mistaken impression. I certainly had no intention to misrepresent. I am happy today to provide as much clarity as I can and answer those questions. What I can say is that no one asked me to lie. What I represented to the committee, the part that was accurate, is that Stellantis did consent to the redactions that were in the version of the redacted document that was shared with you. What I can also say is that my understanding at the time, which was ultimately incorrect, is I had understood that that Stellantis had initially proposed those redactions.
You understood that. You're the deputy minister. It took Stellantis writing a strongly worded letter in response to what they heard you tell this committee. So we were not only the ones under this mistaken assumption that that you presented to this committee, but it was also Stellantis. Your obligation as a public servant is to Parliament, and yet today you continue to represent the fact that you were simply trying to protect their commercial interests by not presenting this committee with the unredacted documents. In fact, in response to my questions last week, Ms. Perusa actually said they were also the ones who proposed that we be given the unredacted documents. So who told you to refuse an order from this committee after it was unanimously agreed to by all members that we would call for the unredacted documents?
Great. Thank you for that question. First I'd say is that the right of parliamentarians to see documents of the kind requested is fundamental to their ability to hold the government, to Parliament, and to Canadians. As part of our regular work, the department does come into possession at infrequent times of confidential information. We are asked at different times to produce those documents. And the process that is typically involved is in...
Mr. Jennings, my question was, who told you not to provide the unredacted documents? It's a simple question. Or were you the one that made that decision as the deputy minister?
The process that we followed was...
I want to know who made the decision, because I'm challenging the process. We're parliamentarians. Actually, I'm going to end there, and I'm going to turn it over to my colleague.
I have exactly the same question. I mean, you make it very clear that your commitment to Stellantis seems to be much stronger than it is to parliamentarians. So I have to ask the exact same question. Who on earth would have told you that you needed to make sure we didn't get to see unredacted documents, which is what was asked for by the entire committee?
So what I can say, which is what I said at my last committee appearance here, was that we try to strike a balance in terms of providing documents that parliamentarians are asking for.
We do have that. We do have that testimony. But what we're looking for now is who would have told you that Stellantis is the one that gets the priority here in this case?
I never said there was a priority.
No, but it seems to be in that
a balance between trying to provide Parliament what it needs with the commercially confidential clauses.
Who would have decided that parliamentarians do not get an unredacted document? That's the basic question here.
No one ever made that decision.
Well, somebody did, because that's what we got.
What we proposed in the letter to this committee was an approach that was adopted in past parliaments where unredacted versions of contracts were shared with parliamentarians. This worked and was accepted by past committees of INDU, ENVI, and we were proposing
excuse me, I have very short time. I know you talked about that last time, that, this is how it's been done before. That's not what we asked for at this committee. What we asked for was the unredacted documents, or sorry, the documents that as we needed them. The entire committee asked for that. and you're saying, well, the other committees, they accepted this, so that's why this decision was made. Is that your testimony now?
My testimony is that is what I proposed to this committee.
So you proposed it. You proposed that.
I proposed that through a process of consulting with Stellantis. We both agreed to sharing a redacted version of the contract.
Which put Stellantis ahead of parliamentarians.
Since that time, Stellantis and ourselves have both shared and agreed to share an unredacted version of the contract. The document is fully available to you now.
Yeah.
And we look forward
we
to,
fought like crazy.
to be able to answer any questions.
Sorry, that is our time. We now have Ms. Rochford, please, for 6.
We thank you, Mr. Chair. Thank you, Mr. Jennings, for being present today. So before we go any further, I'd just like to come back to what the contract says in terms of the consent that's required. Would you be able to read the section in the contract that indicates that consent is required?
I'm going to turn to one of my colleagues. I don't
Yes.
have the actual contract in front of me, so I'll turn to Stephanie.
Thank you.
Are we allowed to read sections of the contract now?
It's been in the public testimony before. I've verified.
So we're allowed to read out of the contract then?
I suspect Ms. Rochford was more making a point and not asking for a specific statement from the
Correct.
contract.
Yes.
While we continue.
So in general, what does the section 60 in the contract on the consent required indicate?
Of the confidentiality clause in our agreement, and this is standard language in our agreements, includes that the party shall keep, each party, so that's both Stellantis and the government, shall keep confidential and shall not consent without the other party's agreement to disclose the information contained within that agreement.
And my impressions are as well that there are certain acts of government that you are bound to as well respect. And would you be able to name some of these acts that as public servants, that is your obligation as you pursue your work to also respect these acts of confidentiality? I was thinking, for example, of, Access to Information Act and so on, such acts.
Yeah, so I think that's a good example. So I guess maybe the best way to answer that is just to say that this government takes any obligations it has in terms of confidentiality very seriously, and that is under all contracts that we have and under all existing federal legislation and laws. Access to information is another example, but also clauses that exist in many agreements we have with companies. As I outlined earlier, is that we need this commercially confidential information to be able to do the proper due diligence. At the end of the day, it's because we're essentially trying to ensure that the investments that are made on behalf of Canadians are done with the best prudence as possible. And in return, the companies seek that they trust the government to not share that information without having their consent to do so. The access to information law is different in terms of how it's structured versus the how it is in contract, but ultimately the consent of the companies is required to be able to share those information either publicly in ATIP or in this case with Stellantis with the condition that it be shared with this committee in camera.
In my understanding as well that such contracts, they have terms and clauses that dictate how funds are dispersed, milestones, for example. Would that be the case with this particular contract as well?
That is typically how contracts of this size would flow out. Is at the end of the day, these are multi-year projects, so there typically would be flows and payments would be made against expenditures that are made by companies.
As well, employment targets would typically form part of such contracts?
It would be certainly typical in terms of what would be there. So benefits, which as examples, would be jobs, it would be capital expenditure investments, it would be R&D investments, IP investments. So these are the types of things that are typical in contracts. And we do see which hopefully you'll understand, is at the end we seek to maximize the benefits to Canada as we make investments. And in addition to benefits, we also have clauses related to non-performance against those benefits, and that's also typically found in these kinds of contracts.
But I was satisfied, Mr. Chair, in reading through the contract that those clauses were there, and I found that a very good, well-structured contract. And I did want to come back to a comment made by Mr. Patzer. I thought it was an excellent question he asked at the last one of our last meetings. He did say, in Clause 16.1, does that supersede Parliament, or does Parliament supersede Clause 16.1? I think that was an excellent question. Or Mr. Béchard answered. He says in Clause 16 in the contract, it's a typical confidentiality clause that we expect our public servants to try to respect as they do their work. But those clauses do not override the die power of certain bodies, including, as you pointed out, Madam Jansen, the courts and Parliament, to compel the production of documents. But in trying to understand die power, I've gone to look, and it does come with certain obligations, right? And I guess as we do this discussion, review the contract in camera, that is in a sense die power being exercised. And I guess my question is directed here to Mr. Bedard. Would that be proper, Mr. Chair? To
Yeah,
do
sorry,
that?
I should have mentioned as before, as I mentioned before, I've paused your time. As I mentioned last time, Mr. Berdar is with us. Feel free to direct questions directly
okay?
to him.
Yeah.
Go ahead, sir.
In the contract, and as you paraphrase my evidence from the last meeting, those confidentiality clauses do not bind the courts, do not bind Parliament, do not bind bodies that have the power to send for records. That's just, you cannot override by contract a legal power. Now, just as court, the party can make a request so that certain information not be disclosed publicly, a witness, a party before Parliament can make a request that certain information be kept confidential. So that will be, for example, only for the consideration of members at the in-camera sessions, or that there may be special safeguards that are put in place for the consultation of the documents. But that is at the discretion of the committee. The committee has to consent to it. Ultimately, the committee has the power to send for records and may insist on the production of unredacted documents. And then it's for the committee to decide as it sees fit in terms of distribution.
Thanks. That is our time. Mr. Lemaire, welcome back to OGGO. 6 minutes, sir.
Merci, Monsieur le...
Thank you, Mr. Chair. You know that you cannot use vinegar to attract flies. I think that also applies to the car manufacturing industry. It can be cyclical. Do you remember that a few years ago, we had to go into a bid war with the Americans in order to attract investments like Stellantis? I've always been critical with that strategy, which is to always outbid others instead of betting on things such as EV batteries and to create a complete sector based on regional resources. For example, extracting the lithium and then we process it there. For example, in Kameng, there is lithium and there's sulfuric acid, and that allows us to build the greenest batteries in the world, while also ensuring that no forced labor is used. We will also ensure that that the most stringent environmental standards are applied. Quebec is a leading example of that, of environmental standards. And then industries will all fight tooth and nail to build their cars in Quebec and in Canada, because then we can build the greenest products in the world. And that's how we make them invest here. But the strategy developed over the course of the past 4 or 5 years was not that. They wanted to use money because of the trade agreement developed with the states, and now that's gone. However, the sector was not developed, and now Donald Trump is here, and that breaks everything apart. And now Stellantis wants to move its operations elsewhere. That's problematic, and Canada is now in a tricky situation. There are many issues in this. Stellantis, Honda, and Volkswagen, who have been there, they have signed agreements to the tune of tens of billions of dollars. We felt this less in Quebec because of Northvolt. So we see that SMEs are gravitating towards EVs, but a lot of works is in Ontario, despite the fact that Quebec is a pioneer when it comes to the electrification of electrification. But in the case of Honda and Stellantis and Toyota, are the contracts similar, or does Stellantis have a specific contract? When it comes to the contract with Stellantis, it is not only about electrification. Volkswagen is an example. Nexstar is another example where there is this very unique structure in order to try to promote battery production in Canada. It reflected the incentives created in the States at the time. So it was related to the manufacturing and the sale of batteries in Canada that would be eligible for a subsidy equivalent to what was implemented in the USA. Back then, the idea was to ensure that the global trend towards electrification, it has been delayed, but it is still continuing. It is fairly advanced in certain parts of the world, and Canada wanted it to be part of the automobile sector of the future, and that's why batteries were necessary. That's why we had to adopt a unique approach and subsidize production. As for Stellantis, it is a fairly typical investment to develop car models in Windsor and Brampton. The only other thing that I would like to add is that it includes the production of EVs. 2 models of cars are produced in Windsor. I appreciated your mea culpa in your opening statement. However, I think there is an overall issue. Of course, transparency and the willingness of the Canadian government to be accountable, especially the Department of Industry. However, how, and this was before your mea culpa, how did the decision you make can impact how other companies, multinational companies who may want to invest in the Quebec and Canadian battery sector, because there are resources there? Maybe these people fear that confidential information may be disclosed, and has that impacted your decision? I'm not sure if I can entirely understand your question. Let's say you publicly disclose a contract. Will others also fear that they will be under the same spotlight as Stellantis now? When people do business, we should have learned from the past. We should learn from what is happening now. What kind of message does it send to others, including investors? I will answer to the best of my capabilities. As I have said a few times, it's a balancing game. We need to balance the fact that there is a lot of sensitive information with the fact that Parliament should have access to the information that it wants to see. And we need to be able to do our due diligence to ensure that things that are shared will not jeopardize competition. It's something that's often discussed with businesses to ensure that it does not create long-term competitive problems. So we're trying to protect that right. In past parliaments, there were agreements with committees where copies were redacted, but lightly redacted, and then they were shared with committees in camera. I think last time we did this, it was with the Environment Committee. 23 companies were involved, and all 23 companies agreed on redactions.
Thank you, Mr. Chair. Mr. Jennings, at the last committee, you basically threw Canadians under the bus, you threw Stellantis under the bus, and you threw the previous deputy minister under the bus by saying that he's the one who issued this contract, and that is. But you keep saying that it's a standard contract. Is this still the type of contract that your department is going to put out going forward? This very same contract? Will you use the same template going forward?
Thank you for that question, Chair. I'll answer the question by saying that we do have a standard template that we start off for contracts with any company, and then we modify it based on the types of investments that are being proposed and the types of commitments that we're trying to secure. So there is modifications from a standard contract. So we don't ever take an exact contract and share it with another company. We essentially modify it based on the sector they're in and the types of investments that they're proposing to do and the types of commitments that we're trying to secure.
Do you accept that Parliament supersedes the Access to Info Act?
I accept that Parliament can get access to documents it requests. Yes.
Okay, thank you. Mr. Chair, I've got a matter of hand motion I would like to move, if that's okay. I'd like to move that the committee classify as public the redacted copy of CIF agreement number 813-816251 and amendment agreement number 1 and amendment agreement number 2.
Great. All right. Did you wish to speak on that? I have
yes,
I have Mr. Seaback and Ms. Khalid.
Yeah, absolutely. I would just like to make a couple of remarks on it because, we had Stellantis come here and say that all the redactions are for the commercially sensitive information, and we've had this confirmation from these folks here today, but also last week, that it's the commercially sensitive information that is redacted, and the minister has been clear that she is going to, or that she is suing Stellantis, and we know that in court proceedings that these types of things will be made public anyway. So I think that it's only reasonable for the document to be made public. But of course, I'm only asking for the redacted copy. I'm not asking for the unredacted copy.
Mr. Seaback.
Yeah, thank you. Thank you very much, Mr. Chair. I think a summary of what we've heard at committee so far is very important and relevant to why this motion should be supported, and I hope it's going to be supported unanimously by all parties. What we heard very clearly when Stellantis was here is that the whole contract isn't commercially sensitive. That's on the record. That's what the Stellantis representatives said when they were at committee. I then asked her if all of the commercially sensitive materials had been redacted in the redacted version of the contract that we received. And she said, yes, that is what has happened. And we know that these redactions are what the Government of Canada would consider to have been commercially sensitive because they were the ones that did the redactions. We've now figured that out. We heard it was a collaborative thing, but no. In fact, it was the department that did the redactions, and clearly they would have redacted what was ever considered to be commercially sensitive to the government. So what we have now is a document that is not, the commercially sensitive parts of that document are not going to be available to the public. And I will echo what Mr. Patzer said. As a former litigation lawyer, what I can tell you is this. The minister says she's going to sue Stellantis. As part of that lawsuit, the first stage of that is going to be the drafting of the pleadings. And in the pleadings, they are required to outline their case. And in those pleadings, outlining their case will include citing sections of the contract that they are relying on for the breach. This would include things like the job guarantee, because the minister is alleging that that was breached. If you're going to allege the jobs guarantee was breached, you're going to have to cite that section of the contract in your pleadings. So that is going to be public shortly, as the minister has said that she is going to sue Stellantis. As you move on in a lawsuit, you move to documentary production. And given that this is the document that the lawsuit is based on, this document will be produced through the documentary production process. Lawsuits are public. That's how our lawsuits work in this country. So this document in its entirety, without redactions, will likely be produced in the lawsuit. So what we're asking for the committee to do now is release the redacted version, which protects all of the alleged commercially sensitive material. So you have to ask yourself, why would this not be supported? I suspect my colleagues across the way are not going to support this motion, and you have to ask yourself why, right? So if the government itself redacted what they thought was commercially sensitive, Stellantis has said the commercially sensitive materials have been redacted. The only thing they're trying to do by not releasing these documents is to protect themselves from the embarrassment of what's in the contract. So I want to be very clear with Canadians on this. This contract is an embarrassment, and these Liberals are going to probably seek to stop the production of this contract to protect themselves from some of the very embarrassing decisions they made in the contract. They're probably going to filibuster this motion, hoping that the Christmas adjournment will come and that they can once again hide the details of this contract from Canadians. On that, Mr. Chair, I would suggest that if they do decide to filibuster, if the Liberals do decide to filibuster to block the release of this contract to protect themselves, perhaps we should extend the meeting on Thursday. I'd be more than happy to sit till midnight or later in order to get this document released. I leave that in your discretion. And with that, Mr. Chair, I am urging my colleagues from the Liberal Party to not hide this contract from Canadians and agree with this motion. Thank you, Mr. Chair.
Thank you. I have Ms. Khalid.
Thank you. Thank you,
the
Chair.
speaking list is open. Go ahead, ma'am. Sorry.
Thank you, Chair. To be clear, work always comes first. I am more than happy, and I know my colleagues are also more than happy to sit for as long as we need, for whatever day it is, to make sure that the work of this committee gets done, to make sure that Canadians are well served. Absolutely not a problem. I just had a question, and actually, before I get to my question, I want to be very clear. I think all members on this committee have provided effective scrutiny as to what has happened here. I don't think any of us have been defending anything. We have been fulfilling our duty and our role as members of the mighty OGGO. And making sure that government is held to account, to make sure that in the future that we do governance better, that we enter into contracts better as well. As members may know, we agreed to make sure that we had this meeting today on the topic that it was today. So I think it's very disingenuous for members to make accusations against other members on this committee about their intentions. Mm-hmm. With that, I just wanted to seek a point of clarification from you, Chair. I know that one of the Conservative members had moved a motion on December 4th, and I just wanted to know, how is it different from what Mr. Patzer has moved today as a matter at hand? And then also, what happens to that motion if we dispose of this today? I mean, I would think that it's basically the same thing from my understanding.
It wasn't moved. It was only read into the record, so it's not moved. So that's kind of moot point.
Is it the same motion, Chair?
It's different, but
It sounded the same. But
Can it be circulated?
Yeah, can we circulate what exactly Mr. Patzer has moved today?
do you have that in writing?
Just to understand.
But it's regardless. It's not because that one wasn't moved. It's not the same. So normally the rules are you can't bring in the same one.
Chair, so the only, I'm not questioning whether that can come or go or what have you. I just wanted to know, does this then remain on notice for members to move at a later time, or if this motion today is passed, that it would then become moot?
Oh, thank you.
Probably, well, I would assume it becomes moot because I can't imagine if this one passes someone else moving it, but because it's on notice, it can't be moved, I assume.
Yeah. It's basically the same. But that's it, Chair. I don't have any other remarks. Thank you.
Right. Seeing no one else on the list, well, Call for a vote, please.
Mr. Gasparro?
Yes.
Ms. Khalid?
Yes.
Madame Rochefort?
Oui.
Ms. Sodds?
Yes.
Ms. Bloch?
Absolutely.
Ms. Jansen?
Yes.
Mr. Palzer?
Yes.
Monsieur Lemire?
En faveur.
Yeas pour 8, and nays contre 0.
Passes. We are now on to Ms. Sudds for 5 minutes, please.
I think I'm next. But
I apologize, Mr. Gasparo.
I'm devastated, Chair.
I will be apologizing and resigning in the House of Commons later today. You're right.
Thank you for coming again. So when we looked to Stellantis appearing before this committee previously, there was obviously a lot of discussion surrounding their comments that the government actually recommended the redactions being made. Obviously, there's been a lot of discussion around here. Can you describe how this redaction process unfolds generally?
Sure. So the general, so thank you for that question, Chair. So the general way it functions is really within the confidentiality clauses of the agreements, which are typically that we need to have consent by third parties to be able to release information into either the public domain or into a parliamentary committee. And that process typically involves a back and forth discussion with the companies and the government in terms of what is what's being requested by the committee in this case, and what could be released. The role of the government is typically in this case about trying to ensure that we are as open as possible in terms of what we release, as transparent as possible with the committees, while also respecting and the right of protecting commercially confidential information, which is important for the companies that shared it with us in trust. There are occasions where companies will will offer redactions. In this case, which I've clarified in my comments, we've had a long-standing relationship with Stellantis. We have an understanding of the types of information they feel should be redacted for commercial confidentiality reasons. And in this case, what we did for expediency's sake is really highlight for Stellantis the areas where we thought that they wish to have redacted. Stellantis at any point could have changed and offered to have further redactions. They could have asked for less redactions, but they essentially consented to the redactions that were highlighted for their consideration through that process.
Well, I'm glad you referenced that sort of joint effort because prior to their appearance, prior to Stellantis' appearance, they issued a letter that clearly laid the blame at the feet of your department for the redactions. However, in their testimony, they described the redactions as, and I quote, a joint effort in ensuring that sensitive information is maintained and confidential. Can you explain this apparent discrepancy or, frankly, flip-flop by Stellantis?
Thank you for that question, Chair. For me, the focus, which I'd rather focus on this, is really about the joint effort, because that really is fundamentally how the confidentiality clauses function in these contracts. And our experience with Stellantis, as well as with the numerous companies that we've worked with previous committees on, is really a back and forth discussion in terms of trying to meet the transparency obligations of Parliament with this confidentiality clause. I can tell you from, not because I was in the department at the time, but from speaking to people that did deal with these in the past, there's many times when the department actually pushed back on companies in terms of trying to redact too much information. So it's really about finding the right balance in terms of how do we meet the needs of Parliament without compromising what would be a mistake to do, which is really what's commercially confidential.
Yeah. Well, I'm glad you talk about people, because we've spent the better part of this meeting talking about process that, quite frankly, in the grand scheme of things, the person trying to put food on their table doesn't really care about what some process in Ottawa is about. So my question now is, with the Brampton facility on pause and broader uncertainty surrounding the auto sector, what concrete steps is the government taking to help secure jobs, reassure workers, and maintain Canada's competitiveness against broader pressures from the global trading environment and the changes that are taking place?
20 seconds? Okay. So I'll give a very brief answer. Just to say that since the U.S. government and administration has really redefined the trading relationships with Canada, but with all other countries around the world, this government has put in a number of measures in place over time to try to protect jobs and protect sectors that are most at risk. I could spend, I only have 20 seconds, so I can't spend time going through them, but essentially there's been a number of measures that have been announced over time, including recent ones to increase the supports for the steel and lumber sectors.
Thank you.
Mayor for 2.5.
Merci, Monsieur le Président.
Thank you, Mr. Chair. This is an important issue, Mr. Jennings. How can we trust this accountability process, especially in this context? Committee members are faced with administrative hesitance and a reticence, this feeling that we are not providing information that we need, and that is an issue. So, I understand that you consulted with Stellantis before sending your December 3rd letter. You mentioned that Stellantis accepted the redactions. Could you please table emails, internal notes, any written proof that shows that Stellantis asked for some things to be redacted? This is part of the committee's rules, and this will help our work. Are you also able to ensure that the department did not try to have Stellantis carry the responsibility of these redactions in order to protect itself politically? The trust here is being harmed, and that's good for no one. It feels like Stellantis is trying to throw you under the bus here, so we would like to better understand the situation. Can you please send to the committee any notes that justify Stellantis' position in this redaction situation? I would be happy to share the documents that we have. I haven't seen them myself, but I will make sure that these documents are shared. I will seek to confirm, and Stellantis also seeks to confirm the fact that Stellantis had agreed to sending over the redacted copy of the document. That's not something I can share right now. Was it a conversation, an email, a text? It would have been over the phone or a video conference, or it would have been an email. I need to check. Stellantis confirmed it last week, and this was done before we shared it with the committee. Do you feel thrown under the bus by Stellantis? Do you feel like they are making you carry the burden? What's important here is the fact that they testified last week that this was a mutual effort. Thank you. I can keep going if you wish.
Mrs. Jansen, please, for 5.
Yes, thank you. I just wanted to ask some more questions about process because, of course, regular Canadians who are having a hard time putting food on their table want to make sure that the people who they sent here are worrying about the process to make sure that their tax dollars are spent well. Yes. So you testified that only a few people within industry had seen the full unredacted contract. Is that still your evidence today?
That is still my evidence in terms of the full contract. As I mentioned a bit earlier, there are other departments sometimes that are consulted on parts of it in terms of trying to get access to their expertise to be able to do our due diligence on contracts.
Okay, so the Treasury Board officials that are responsible for spending oversight told us that agreements of this size normally undergo robust legal review before authorities are granted. whereas Ms. Tanton said that there were no lawyers during the negotiations in the room. So I'm just wondering, does robust legal review reflect what happened in this contract?
Yeah, what I can confirm is for all contracts that are signed by ISED, there is a legal review. As Ms. Tanton testified at the last time we were here, is that there are some standard clauses that legal does not need to review for each, but when there are differences in overall, legal justice does give advice.
So in your mind, the $15 billion contract was legal. It was a robust legal review that happened on behalf of taxpayers.
Sorry, just to be clear, do you want me to turn to the Next Star agreement? The $15 billion contract is not the Stellantis agreement.
Okay, no, I'm just trying to make sure that in general, because it looks like, if you look at all these different contracts, robust isn't a word I would use, but perhaps I can send it to my colleague here. I'm going to share my time with her.
Okay, thank you.
Thank you, Chair. Can you advise how much time I have?
Sorry, you have 3 minutes.
3 minutes. Thank you very much. So I think what we've established here today at committee is that you agree with the law clerk's opinion that Parliament supersedes, the will of Parliament supersedes any clause that may be written into an agreement that's presented to a company that is receiving billions of dollars from taxpayers. Is that correct?
I'd be speculative for me. I'm not a lawyer. What I can say is that I respect Parliament's desire to
not
to
Parliament's
get documents.
desire, Parliament's right.
I respect Parliament's right to documents.
Thank you. Okay, so then I guess what I am wanting to confirm is that the clause that we've been speaking about around confidentiality is rather disingenuous to use in a contract, understanding that if a company is being offered millions, even billions of dollars of taxpayers' money, that may come under the scrutiny of Parliament at some point in time. And so I'm wondering if you would agree that it needs to be made clear to a company that's entering into a contract with the Government of Canada that when they are receiving billions of dollars of taxpayers' money, there will be another level of scrutiny applied by parliamentarians to these contracts. Would you agree with that?
So thank you, Chair, for that question. I would go back to what I said earlier, is that commercially confidential information is very important for us to do our proper due diligence. And the company's willingness to share that, for us to do that due diligence, is related to them being able to.
I'm sorry, Chair. That is not the ruling of the law clerk here today. And you continue to go back to that point, which tells me that what you say and what you intend are two very different things going forward. And so I would just caution you that we have the law clerk's opinion on the right of Parliament. You've said you agree to that. Why do you keep referring back to the commercially sensitive information that may be included in a document when we, in fact, as parliamentarians, have the right to call for that commercially sensitive information unredacted?
What I'm highlighting, as I have in my last testimony as well, is that we try to find balance in terms of what Parliament
It is not your job to
right,
try and find the balance. It is your job to comply with the will of parliamentarians.
That's right.
Thank you.
Thanks. We'll finish up with Ms. Suds, please, for 5.
Thank you very much, Chair, and thank you all for being here again with us today and answering our many questions. Now that the committee has passed a motion to classify the agreement as, or the redacted copy, excuse me, of the agreement as public, I would like to ask you a few questions around the job guarantee. So I think that is section 6.3.1. And if you can speak to us about what this clause entails as far as job guarantees.
I'm going to ask my colleague to pass me the contract. I don't have it with me. So. Not memorized, not all of it. So sorry, which clause? Just to be sure.
6.3.1, create and maintain high-skilled jobs in Canada.
Okay. So this clause. So there's a number of. So let me just give it the broader context. There's a number of clauses. I won't go through all of them now in terms of trying to secure benefits. In some ways, this one is clearly a direct job support, but there's other clauses within the agreement, including maintaining footprints in Windsor and Brampton in terms of CapEx investments that indirectly also support jobs. So it's combined. They are a strong measures that at the end of the day are all about supporting jobs. In this case, this is really about trying to secure a certain level of full-time equivalents in terms of the entire footprint of Stellantis has in Canada. So those would be 2 sites in Windsor and 1 site in Brampton. And there is some flexibility within the numbers. As you can see, we're using kind of an average FTEs, and that's recognizing that there are times, which is typical in the auto sector, where there's some retooling that has to occur between car mandates. And during that time, the workers are typically negotiated with the unions, in this case Unifor, where they have an agreement that a certain level of workers are paused in terms of their work, and then they come back once the plant is reopened again. So in some ways, what's listed here is a negotiated agreement with Stellantis on what are the minimal jobs that we expect to have for them during the life of the contract. But in the broader context, that there are other clauses in this contract that we think also have job implications, notably maintaining operations in Brampton and while also maintaining operations in Windsor.
Thank you for that. And I certainly think as members of Parliament, seeing those efforts to ensure job creation and job guarantees as part of the agreement is incredibly important for many reasons, but of course, namely ensuring these good jobs, are maintained, created and maintained in our communities. Is this typical? Is this something that we normally see in CIF agreements of this size?
It is certainly typical, and I actually have never seen a CIF agreement or an SRF agreement, as it's been renamed, that have not included job guarantees. Having capital expenditure guarantees is also typical. Innovation R&D investments are also typical. What can vary, as an example, is IP. And that would really depend on the sector you're supporting. But these are all typical things. And at the balance that we're trying to strike is what risk is the government helping support so businesses can invest in Canada, while also ensuring that there's a good public rationale for doing so, which includes what commitments that the companies are making to Canada. These agreements always include non-performance clauses. So at the end of the day, if there is non-performance, there are remedies that the governments can access if people do not meet the benefit commitments that are outlined in contracts.
Okay. Thank you very much. That's all, Chair.
Wonderful. Thank you very much. Before we adjourn, I just need approval, please. Budget's been sent out. Get approval for that for the continuing meeting with Stellantis. All agreed? Wonderful. Thursday, just a reminder, 3:30 will be done at 5 with the President of Canada Post, whether or not the House rises or not. And I understand there will be Christmas donuts on Thursday. And we actually finish early. So with that, we are adjourned. Thank you again for being with us today. We are adjourned.